time, I'm going to move straight on to ground 2 and deal with any other points on ground 1 in reply. As courts are aware, our second ground concerned whether the tribunal actually had any jurisdiction to contemplate distribution of damages by means of an account credit. And we say that should not have formed any part of the tribunal's assessment, even if it didn't reach a final view on that point. We say that the fact that it clearly did form part of the tribunal's assessment vitiates the tribunal's reasoning. The first point to emphasise is that these are claims for damages, not for an account credit. No one's actually claiming an account credit. It's any part of the evidence before the tribunal in support of the CPO. It doesn't feature in the distribution plan. And in many respects, that's actually unsurprising because, as we saw under section 47A3, the tribunal is only permitted to hear claims for damages, claims for a sum of money, or claims for an injunction. And in our submission, an account credit is not the same as either a claim for damages or a claim for a sum of money. It's not fungible in the way that a sum of money is. It can only be applied in a very limited way against charges for telephony services from BT. So it's of no use whatsoever to class members who no longer have a BT account. It's no use whatsoever for persons who are deceased. The class representative has sought to argue that the type of relief claimed is an aggregate award of damages and that the account credit is just a possible means of distribution of those damages. But in our submission, that is wrong for exactly the same reasons. If you think about what's happening when you confer an account credit, you're not distributing damages. You can't use that account credit for any purpose in the way that you could an award of damages. It is essentially some sort of contractual entitlement as between the class member and BT, which can be applied against future charges for BT services. The compensatory principle envisages that an award of damages will put the class member back in the position they would have been in but for the wrong that's being compensated. If you ask, is the class member put back in the position they would have been in by the award of an account credit? In my submission, clearly they're not. They would have had money which they can apply to any use. Instead, they're giving them an account credit which can be put against telephony services, so it doesn't satisfy the compensatory principle. And indeed,
surely what they're being compensated for is money having gone out of their BT account, being debited to their BT account.
They're being compensated for having, on their case, having paid more than they should have done for telephony services.
Money being debited to their account, so it's reversing the debit, isn't it?
Well, my lord, it's not, in the sense that to reverse it, you would then have the money. You wouldn't simply have something that you can then put against your future liabilities to BT.
But if you terminated your contract there and then, you'd have the money on that hypothesis.
Not if you're compensated by way of account credit.
Well, if you...
They'd have to, they would, let's say the clock stops, so you terminate the contract at a time when you've got the £200 credit, and you decide you no longer want to be a BT customer. So you say, I'm terminating, you'd be entitled to receive £200 from BT.
I'm not sure you would, my lord. It's not that assumes that it's essentially equivalent to damages where it isn't.
It's a method of paying them their damages, and they would always be entitled to say. That's my. I mean, if it went onto the bill as £200 damages from competition claim or something like that, then they would be entitled to if in my example they terminated, they'd be entitled to pay the £200.
People who owe BT money, it would be a set-off.
Yeah.
And so it would just be BT applying the set-off, or alternatively you could regard it as a running account. I don't see any difficulty in it being a payment of money or money's worth, certainly to existing customers. I can see with former customers that whether you could pay it into an account might be a more difficult question. But if they did pay it, if it was paid into a reopened or notional account, then they plainly would be entitled to be paid over that sum.
My lord, it is an involuntary set-off.
Well, it may be an involuntary set-off in one sense, but on the other hand, If any given customer said to BT, I don't want this done by way of an account set off, I want an account credit, I want my money. BT, you say, yeah, okay, here's a cheque for £200, now you owe us £200 more.
I'm sorry, I didn't follow that example, my lord, because if the customer said to BT, I want my money, what the customer is saying is that I don't consider an account credit to be compensatory damages, I want a payment of damages, and that is the submission that I'm making. They are not the same thing at all.
Well, it's because as a matter of practical reality, no customer is ever going to say, I want my £200 as a cheque, please, because they're going to immediately have to pay the £200 back to BT if they're going to running an account with BT.
Well, my lord, in my submission, that's not right. They are not immediately going to have to pay BT £200. They have a cheque, and they can do anything they like with it. And that, one might imagine, is the position the class member would want to be in.
Yeah, but their liability to BT is increased by the £200, isn't it?
My lord,
Because
no,
on this
there's
hypothesis, they don't get the account credit.
my lord, there's no assumption of any liability to BT at all.
But why wouldn't BT be entitled to set off in equity any sum of damages against liability on an account? You'd be entitled to do that anyway.
My lord, they wouldn't, and nobody's claiming that they should be. But what's being suggested is that this facility to set off damages against future liability to BT is the way in which the class members should be compensated.
Just so we're clear about the mechanism, under the 2007 commitments, BT, as it were, remedied the position for the future by reducing the line rental by the amount agreed with Ofcom. So
My lord, that's correct in relation to voice-only customers.
was not in relation to CP customers.
And no
Split.
concessions were made in relation to...
And so the issue that is subject to the claim is the past claims where BT didn't retrospectively apply a cure because the Ofcom remedy was prospective only. So the claim now, as it were, covers the gap.
For the voice-only customers,
the
and it's
VO
ongoing
customers.
for the split purchase.
That's right, because they just simply, Ofcom said there has to be greater transparency, but they didn't impose the line rental reduction for the split customers.
Ofcom didn't impose anything, but the settlement that was reached,
They agreed with
which
the commitments.
applied solely
Yes.
to the
Yeah.
voice-only, yes.
So if there is a claim for damages, it's in relation to the past. You could have it set off against the future, but there's nothing to stop the CAT making a variegated order if it so wishes, an account credit for 2 million, an award of damages for 300,000, on the hypothesis that the claim wins everything is there. I mean, they can box and cox as they see fit.
My lord, I am going to come on to say there is something to stop the CAT doing that because a direct payment is not permissible under the scheme. But there's a prior point here, which is in my submission offering an account credit against future BT, essentially liability to BT for your phone services is not in my submission.
You say
And
it boils
award
down to
damages.
this. You say it ain't damages as legally defined.
That's not a problem here because sorry, I interrupted.
No. So the issue is and under the scheme, the tribunal, if it's against you, makes an award of damages. Because it's opt-out, it has to be paid either to the representatives or the other party authorised. There's then almost a complete dearth of provision in either the Act or the rules which governs what's called distribution. The question, therefore, is whether in exercise of its case management powers as distribution, it can distribute the award of damages in some other means, some other method, for example, by an account credit.
The submission I am making is that granting account credit is not equivalent to distributing an award of damages because instead of conferring upon the cast member a
So
sum
it does
of money
boil
that
down
they
to
can
what's
do...
meant by distribution. Can the CAT, within its powers, distribute the award of damages by some means which it considers as convenient and effective in ensuring compensation? And that's what it boils down to. It's really not so much what's meant by damages, but what's meant by distribution.
My lord, in my submission there's a separate point about what's meant by damages or an award of a sum of money.
But assume you're right on that the damages at that point paid into the hands of the representative or the other party has to be damages, or paid to, or BT required to hold a sum of money, qua damages. It then is distributed. And the question is, does it have to be distributed as damages, as a fixed fungible sum, or can it be distributed by some other means which the CAT considers just, equitable, fair in all the circumstances?
because it's made an award of damages when it awards the 589 million on this hypothesis, which it orders pursuant to section 93. It's paid to BT, say. That's the award of damages, paid to BT with a direction to BT that it's to be distributed to the customers, to the individual claimants, so that they're compensated by way of an account offset, except in those cases where the customer is no longer a customer or is dead.
My lord, in my submission, that solution is kicking the can down the road, because while the tribunal might seek to characterise what is held at the first stage as acquired damages, if you ask what has the class member received, they have not received a sum of money that they can apply to whatever they want. And it's surprising that the class representative acting in the interest of the class members would be advocating for a credit which has a limited utility over the receipt of a sum of money that they can apply in any way they wish.
Well, just one moment. The money that's paid, let's say it's paid to the representative and then is distributed through BT or however into these different bank accounts, these different accounts. However the money is ultimately paid to the customers, the claimants, it is going to be a credit to an account, even if that is to a bank account.
My lord, yes. It will be a credit to an account that they can apply for anything
and what
they
a
want.
bank account is a debt. And if the customer's account is overdrawn, it will simply be credited against that overdraft. They can't spend the money as they wish. It goes in reduction of the overdraft.
My lord, it would be a surprising conclusion to say then that it's sufficient simply to offer a credit on a telephony account because of the prospect that if you paid it into a general purpose bank account and it went into an overdraft, that would offset the overdraft. That money is, by definition, if you pay it into a general account, it's being applied to something other than telephony services, being applied for a different purpose, and it must be for the class member.
To be paid in reduction of the overdraft.
It must be for the class member to be able to apply its award of damages in such ways it sees fit, including perhaps by setting off an overdraft.
Well, you can't. If it goes into your bank account and it's overdrawn, you've got no choice. It reduces the overdraft, and that's it. You've got no choice about that.
Well, the class member has no choice whatsoever, even to apply the money to its debts with the bank, if it is confined to only using it.
I see that if money is owed to BT, in fact, it seems to me it's even less problematic because at that point, BT is entitled to set off.
My lord, there is no basis to assume in relation to these class members that they necessarily owe money to BT at this stage.
Well,
they will as and when they consume services.
In that case, they'd be entitled to payment of the credit balance on their account.
Would there be an objection, if this is about consumer preference in your view, could there be any objection to an order made by the CAT that the award is to be distributed via an account credit unless 1, the customer is deceased, 2, the customer has terminated the account and no longer has an account credit, 3, any customer within 8 weeks writes to the administrator, CAT, whoever, and says, I want a sum certain. And then all those 3 are dealt with by fixed sums, and the remaining 99% are dealt with by an account credit. That would take account of, CAT could make that order, and there'd be no objection then from a consumer rights, consumer flexibility, consumer freedom point of view.
Because the consumers would have the opportunity to say, I'm not happy with that arrangement, I want my £200 so I can go down the pub or whatever.
My lord, that solution runs straight into the difficulty we have, that we are being told that these are a disengaged class. The entire purpose of the tribunal advocating this as a possibility is so that the customers do not have to actually positively engage in any way whatsoever in order to be the recipient. And so a solution which envisages that they must engage in order to specify their preferences doesn't seem consistent with that. But there is, I think we're getting bogged down in my submission that this is not, that an account credit is not equivalent to a form of money. There is a more fundamental problem in my submission, which is that we've seen the mandatory language in section 47(3)(c), C3 and CAT Rule 93(1), and both of those provisions make clear that in the case of opt-out proceedings, the tribunal shall make an order to be paid on behalf of represented persons. either to the class representative or to some other person other than a represented person.
And
And in
that's
my
all prior to distribution. That's what the rules then say, that's payment of an award of damages. And then the rules get into an entirely new process called distribution, as to which there are, I think, only either two or there are three ways in which the rules intervene. One is to require the payment to the person who's going to do the distributing. Two, to create a power to set a fixed date for claims. And thirdly, the residual default position in relation to allocated funds to charities. Everything else is left to case management powers of the CAT. The rules just don't embrace or touch upon anything to do with modus operandi.
In the example we've been postulating, the CAT, pursuant to Rule 93(1), orders payment to BT of the damages that it is liable to pay. It says you, BT, will hold those damages, so we're now complied with 93(1), but we direct that, and then 1, 2, 3, as my lord suggests.
In my submission, the artificiality in that is the notion that there would be an award of damages payable by BT to BT in order to give the impression that there's been some form of distribution and thereafter the CAT has discretion to do that which it wishes. In my submission, the reality of what's going on is that the CAT is contemplating a payment directly to the class members, and it either seeks to interpose some other claims administrator, but there's no reason for there to be a direction that there be payment of damages to the class administrator, because the class administrator wouldn't then distribute the damages. They'd be simply operating a mechanism whereby they confer credit on particular accounts. And it's even more artificial to suggest that in order to circumvent this problem, one must direct that BT pays BT, thereby directing that it's payable one person receives the money, and then after that one then proceeds to essentially make a direct transfer.
By ordering it paid to the class representative for him to then transfer to BT, back to BT for it to distribute.
BT sets up a small distribution company to hold the funds, and it's paid for from head office to the new company, Distribution Co. for distribution. But that could be overcome, I think, if I had to go down this technical advice.
The process of actually creating a flow of funds isn't really necessary. If what's going on is that you're conferring an account credit on individuals, one queries, why is it necessary to have an order that BT pays money to anybody and then that money is passed elsewhere? Essentially what is happening is that BT confers an account credit and that there's no real flow of funds.
That's what the rules do say. There's a mandatory disposition from defendant to either representative or some other person. So whether that's good or bad, that's just what the rules say. And then the question is, what happens next when the money is in the hands of administrator, legal representative or BT? It's then distributed. So the question is, in the CAT's almost unlimited powers over distribution in the rules, can it order distribution via some method other than a fixed fungible sum? You say no.
My lord, your lordship is putting to me that that's what the rules say, and I would endorse that in the sense that there is a reason for the rules directing and envisaging that there will be a flow of funds from the defendant to either the class representative or another person and onward to those who receive it. And insofar as the tribunal's proposal envisages some sort of artificial means by which that flow of funds is created, notwithstanding that in reality what's going on is simply conferring an account credit, that in my submission is an indication that this is not what the rules intended to happen.
Can you identify a policy reason why the CAT shouldn't have the power to order an account credit? Are there any policy reasons which would, you think of the counterfactual, what would happen if whoever it was had to contact 2.3 million people and say, can we now find a way of sending you some certain fungible sum? The costs, the time, the effort of that would be immense, even with the platform advantage of knowing who they were. What possible benefit in policy terms can there be from denying the CAT the power?
Well, the closest we've been able to get to that is the explanatory notes that we showed your lordships this morning, which explain why it is that even in opt-in cases where the tribunal is permitted to make direct payments, there is a tight judicial control over that possibility. And the submission I make is that given that the statutory scheme has, first of all, expressly provided the CAT may not do that in relation to opt-out proceedings, and it has established a scheme in which even in opt-in proceedings that possibility is tightly controlled, it would be inappropriate to seek to circumvent that.
But here surely it would obviously be completely inappropriate for there to be an order that monies are paid directly to the 2.3 million customers. The order instead is that the monies are paid to the representative. They go into the representative solicitor's bank account, or the representative directs that they're paid into an account at BT for the purposes of recrediting. So there's no difficulty about payment to the personal representative. And the only question, it seems to me, must be whether you're right that it somehow is improper to distribute via crediting of accounts. For my part, at the moment, I can't see why that would be an inappropriate form of distribution, particularly in a case where the very nature of the claim is that the accounts were wrongly debited in the first place.
My lord, I do make the submission that you are essentially artificially interposing further stages into that process in order to create the impression, as contemplated by the rules, that one transfers damages to a particular person and that person distributes them.
Well, one can see from the rules themselves, one of the things which is being looked at here is what is pragmatic. That's one of the key questions in deciding what form of vehicle is going to be used here for compensating large numbers of consumers, and surely this is the pragmatic way of dealing with it.
And although the rule is mandatory in relation to opt-out proceedings, it does expressly contemplate circumstances in which, for whatever reason, the tribunal will order payment to somebody other than the class representative. And the reason for that or a reason for that may very well be because the class representative says, well, I don't have the practical means of distributing the money, the damages to the individual claimants. Please, CAT, make an order that helps me to achieve that by saying that BT should distribute it by way of a running account. Anyway, we've interrupted you enough. You've got the point.
Grateful. In our submission, the third point I make under this head is that I've shown you, Your Lordships, that the statutory scheme clearly contemplates represented persons will take active steps to claim their entitlement. I showed you Rule 93.3 in the references to shall claim their entitlement and setting a date by which it shall be claimed. And in our submission, because the entire scheme contemplates active steps to claim, it is inconsistent with that to come up with a scheme whereby one simply credits the account of a member of the class without any such active steps. It's also informative that the scheme makes provision for what happens with unclaimed sums, including that you might end up with an order for costs of expenses to be paid to the class representative. And it's worth pointing out that the class representative in this case is contemplating that might happen. So, for Your Lordship's reference, Mr Le Patourel's first witness statements, paragraphs 105 and 106, explain that he envisages making an application under that provision. And again, in my submission, it's inconsistent with a distribution of aggregate damages by means of crediting to the accounts, because that would mean that there would be no unclaimed sums. And finally, in our submission, there is a tension between the tribunal's notion that the entire proceedings can somehow be conducted without any contact with members of the class, for the tribunal to acknowledge in the context of the pass-on defence that it might well be necessary to contact class members in the context of adjudicating that defence. In our submission, that illustrates the incoherence of the reasoning. The whole point of the tribunal contemplating this mechanism is to support the proposition that there's somehow a difference between requiring class members to opt in at the outset and at the distribution stage. But of course, before you get to distribution, you have to establish quantum. And on the tribunal's own reasoning, that might well entail a degree of participation from class members. So in our submission, that simply illustrates the incoherence of the reasoning that's being put forward here. My Lords, those were my submissions on ground 2. I'm moving on to deal very briefly with ground 3. As the tribunal, as the Court of Appeal knows, this is the ground which concerns the approach to assessment of the merits in paragraph 124 of the judgment.
Well, you've already made your submissions about that, I think, haven't you?
My Lord, I think you probably have got the essence of what we say.
We agree it's messy. The question is, what does it mean and what are the implications of paragraph 124?
My Lord, the core of our submission is that by applying a test that the claims would have to be very weak before taken into account, the tribunal has created a test which is not reflected on the face of the scheme. And therefore has not properly taken into account the merits in reaching its assessment as to whether opt-in or opt-out should be the most appropriate way to certify these claims. Well, I think your Lordship's right. We have essentially canvassed the essence of that ground. Unless I can assist your Lordships further, those are my submissions.
Thank you very much, Ms. Ford, thank you. Yes, Ms. Grisman.
If it please the court, my lords, the central issue in this appeal is whether the Competition Appeal Tribunal acted lawfully, that is, within the bounds of its discretion under Rule 79(3), in approving the opt-out basis of these proceedings. The position of the class representative, Mr Le Patourel, is that the tribunal did exercise its discretion lawfully, and its consequent judgment that these proceedings should be brought on an opt-out basis was lawful and indeed correct. Because the headline characteristics of this class and its members, each of whom is a BT landline customer, make this a paradigm opt-out case, exactly the type of case for which the opt-out procedure was introduced. And those characteristics are, in summary, as your Lordships already have it, a sizable class made up of 2.3 million individuals. Those customers are overwhelmingly consumers, not businesses. Each of them suffered low individual amounts of damage. A significant proportion of them are elderly, lower income, vulnerable, and by definition to come in the voice-only subclass, have no broadband connection in their homes. These are also people that didn't switch supplier, and that applies to both subclasses. Legacy BT customers who didn't switch over to cheaper deals. My lords, on BT's case, these customers would have to make a decision to opt into technical competition law proceedings and take the positive steps necessary to join the action to pursue their right to compensation for the overcharges that form the subject matter of the case. That requirement to opt in would raise a barrier to effective access to justice for these customers, a barrier which would, in practice, stop these proceedings in their tracks. Because what we know about consumer opt-in proceedings, as your Lordships have heard, recently powerfully articulated by Lord Legate, and I will, if I may, address your Lordships briefly on Lloyd Google. But what we know about these large consumer opt-in proceedings is that they rarely get off the ground. And one of the principal reasons why that is the case is human inertia. It's not a mere matter of form filling. It's reluctance to take positive action where the consequences are hard to understand and they are uncertain. As your lordships have pointed out, it's really a question of incentives. The fundamental difference in incentives between accepting payment and joining complicated litigation. And that's at the heart of my submission today. That means that if the opt-out procedure were withheld from this class, as BT seeks, the members of the class who have already been found by the tribunal to have a real prospect of success at trial will, in the words of Lord Briggs in Merrick's, be denied a trial by the only procedure available to them in practice. My lords, that's by way of introductory remark. With your permission, I then propose to structure my submissions in the following three parts. First, the nature of the tribunal's discretion under Rule 79.3. I'll then, secondly, turn back to the relevant parts of the judgment, and then lastly, address BT's various criticisms under the three grounds. So beginning with discretion, my lords, Miss Ford has already taken you to the rules, but if I could perhaps just ask you to have them in front of your lordships. That's the authorities bundle, page 67 at tab 6. And then turning forward to Rule 79 on page 67.
So tab 6.
Tab 6 of the authorities bundle, page 67.
Yep.
My lords, you've been taken to Rule 79.3. The wording is clear on its face. In determining whether proceedings are to be opt-in or opt-out, the tribunal may take into account all matters it thinks fit. That is an unfettered discretion on the part of the tribunal. It's not required to have regard, nor is it required not to have regard to any matters. It's for the tribunal's judgment as to what it considers relevant to the assessment. And we now have the benefit of the Supreme Court's construction of that phrase, all matters it thinks fit. If I could ask your lordships to turn forward to tab 9 in the authorities bundle, that's Merrick's, page 171. Here, Lord Briggs addresses the same general rubric as it appears in the prior paragraph, the prior subparagraph of Rule 79.2 on suitability for collective proceedings. Lord Briggs says, the listing of a number of factors potentially relevant to the question whether the claims are suitable to be brought in collective proceedings in Rule 79.2 within the general rubric, all matters it thinks fit, shows that the CAT is expected to conduct a value judgment about suitability in which the listed and other factors are weighed in the balance. Those factors aren't separate suitability hurdles, each of which the applicant for a CPO must surmount. His lordship went on at paragraph 63, at the end of that paragraph, and he's addressing certification there. It is the tribunal to which Parliament has entrusted both the exclusive jurisdiction over collective proceedings and, in particular, the conduct of the task of certification with wide discretionary power for that purpose. And then over the page, his lordship goes on. He cautions that the question of certification involves a single multifactorial balancing exercise in which too much compartmentalisation may obscure the true task. The same approach applies to the tribunal's assessment of the opt-out question, because very simply, the same wording is used, all matters it thinks fit. The only difference is that instead of a non-exhaustive list of 7 matters, for the opt-out question there are 9 in Rule 79.3. Lord Sales, in the minority judgment in Merrick's, made a similar observation at paragraph 111, which is at page 184. He says, and again emphasises the wide frame of reference to be adopted by saying that the CAT shall take into account all matters it thinks fit, and providing a non-exhaustive list of matters which the CAT might think fit to consider and place weight upon. The width of the frame of reference in itself shows that the CAT's judgment as to suitability is central, since the very wide range of matters to which the CAT might have regard, the disparity in their nature and incommensurability means there may often be wide scope for reasonable differences of view about what relevance or weight should be given to what factors and what overall conclusion should be drawn on the suitability issue. The Act and the CAT rules identify the CAT as the body whose judgment matters for that purpose. And of course, on that point, his judgment is on all fours with the majority judgment. My Lords, turning back to Rule 79.3, Miss Ford, as you know, places heavy emphasis on the reference to practicability in subpara B of subpara 3. And again, one notes the very broad language used. The question of practicability is to be assessed having regard to all the circumstances. The only circumstance highlighted in the statute is the estimated amount of damages that individual class members may recover. So again, a very wide frame of reference. And just to note, Lord Sales makes the point at paragraph 109 of Merrick's in relation to that wording, having regard to all the circumstances, which comes up in subpara 1 of Rule 79. So again, identical formulation. As your lordships have already had ventilated, low individual amounts militate in favour of the opt-out procedure, and one sees that in the statute.
But also does indicate the potential relevance of the question of conversion, doesn't it?
It does, given that if your lordship has in mind the breadth of the provision and the difficulties of attracting applicants to the class where individual amounts are low, that's the conversion problem.
Well, and also the factors mentioned in 3 are additional to those set out in 2. It doesn't say they in any way are superior to or govern. They are all, on the face of it, equal. And under 2, it includes in D the size and nature of the class. So it's certainly open to the tribunal to consider that this 2.3 million and a class of broadly described as potentially vulnerable customers is an extremely important factor before you come on to.
Your lordship has
But
it.
3B is also, isn't it? It's looking at the estimated amount of damages for individual class members as bearing on the issue of practicability, because that's the context. Yeah. And the only way in which it really bears upon the issue of practicability, that's to say the amount of damages, as opposed to other things like can you find them, do they know there's a claim, that kind of stuff, is because the individual claims are absolutely minute and therefore, or relatively minute, and therefore it's to do with incentivisation or convertibility, as my lord said.
Your Lordship puts the point more eloquently than I
I'm
could.
not sure I do, but I mean,
It's certainly noteworthy that that's the single consideration in the rule that goes to practicability. But as your Lordship says, it's a wide frame of reference. It's highly fact sensitive. So when Ms Ford makes sweeping statements about what this would mean for the generality of cases, it will never be possible to have an opt-in. One needs to exercise caution. This is a fact sensitive exercise.
You can ask the question, is it practical to have 2.3 million claims from £100 each or £200 each when the other option is not to have them? And the answer is it's plainly more practical not to have every single one of these customers filling in forms to make a claim.
Well, that's absolutely right, isn't it? It's not even, I mean, it goes beyond just incentive. No, they won't have an incentive to, as it were, join. It's the cost of that exercise
Completely disproportionate.
is disproportionate and totally unnecessary.
It's a point picked up by the now ex-president of the tribunal in Gutman, and I can check the reference.
Gutman is the other case that is
Under appeal.
under appeal as well, isn't it? Yeah.
That's right. And in Gutman, he says just having so many individuals in a class would be unmanageable on an opt-in basis. So that's another point. It's not just incentives, it's manageability.
Another way of looking at it is if you've got the ability to identify customers, so at the end of the day you can distribute to them, why do you need to have them make a claim? What is the practical sense of it? 2.3 million bits of paper or whatever, all to indicate that the people you know are there and you can credit their accounts at the end of the day are making a claim.
Entirely superfluous.
It seems to me it renders what is a quite straightforward exercise a procedural and administrative nightmare.
I mean, we have never seen in this jurisdiction an opt-in clause that extends to that many people because, as you've heard, there's only ever been one opt-in case in the competition sphere, and it didn't work, and no one wants to touch opt-in proceedings for big consumer claims in the light of that experience. I will take you back to the consultation documents briefly, but the entire thrust of this regime and the statutory objective, as already articulated by the Supreme Court, is to lower barriers to accessing justice, making these procedures more simpler and more efficient. And this appeal runs counter to that statutory objective. But having 2.3 million pieces of paper assumes that one would get 2.3 million people to opt in, which
Let's
seems
assume it's
frankly...
10%, so you only have 230,000 bits of paper.
And then manageability is... manageability becomes less important.
Quite 23,000. Be bad enough, wouldn't it?
Still unmanageable, but more importantly, much of the class goes
But
without
strangely enough,
redress.
the tribunal didn't actually say this, did they? And it seems obvious, but they didn't say this is unmanageable to have tens, hundreds, millions, thousands of pieces of paper.
It's a fair observation, and that's why I refer to Gutman on that point. I think the reason, and in reference to Gutman, just for your note, is paragraph 183. It's at tab 10, page 272 of the bundle. I think, just by way of explanation, it is fair to say that doesn't feature. Much of the discussion in this case, and as I say, each one must be highly fact sensitive, is that one didn't really get to unmanageability because it was so far-fetched to think that these customers would opt in. So manageability didn't really arise because it's rather inconsistent with the principal submission, which is you're not going to get many stepping forward. So if you only have a handful of people, manageability is less of an issue. my lords, as well as having gone to the statute itself, there are 4 additional sources relevant to the tribunal's exercise of its discretion, its wide discretion under Rule 79.3, which are as follows. The Rule 4 governing principles. Secondly, the statutory objective of the collective proceedings regime. 3, sources on the shortcomings of the opt-in procedure. That's the consultation documents which Miss Ford took you to, and Lloyd Google. And fourthly, the guide, which you've already seen. The Rule 4 governing principles should be at tab 6, page 64A of the authorities bundle. They were a late insert. And they're in the manner of the CPR overriding objective. And the overriding governing principle is that the tribunal shall seek to ensure that each case is dealt with justly and at proportionate cost. Well, that's clearly relevant to the availability of opt-out proceedings, which by their nature raise questions of access to justice for the class, and that's a theme I'll return to. Secondly, the statutory objective of the collective proceedings regime, that was articulated by Lord Briggs in Merricks, and that's at paragraph 37, which is at page 164 of the bundle, tab 9. Halfway down paragraph 37D, His Lordship was addressing the Canadian structure regime, and he said of both Canada and our regime here, both may be said to serve broadly the same statutory purpose of providing effective access to justice for claimants for whom the pursuit of individual claims would be impracticable or disproportionate. So when my Lord, Lord Justice Green asked, well, what is the policy objective? The Rule 79.3 must be construed with the statutory objective in mind, and we have the benefit of that here. Also, paragraph 54 on page 170, Lord Briggs, at the end of that paragraph, said the evident purpose of the statutory scheme was to facilitate rather than to impede the vindication of these rights. Now, His Lordship was addressing certification, but the statutory objective is just as important to the Tribunal's decision on the opt-out question, because in practice, many collective claims, such as the one you have before your Lordships today, simply will not see the light of day unless they're brought as opt-out claims.
It is a policy to vindicate rather than impede rights, really a sub-aspect of access to justice. Which you always add the sobriquet effective access to justice.
It is.
It's effective if it is sufficient to vindicate rights.
Yes.
And not diminish them.
I'm grateful, Your Lordship, that's right. And of course, it's a broad objective, and one then has to look to see how to get there on the facts. Now, just turning to paragraph 19 of the same judgments, my Lord Justice Flo asked whether it was appropriate really to go to the consultation documents at all. So it may just be worth having a look at what the Supreme Court had to say. At paragraph 19, Lord Briggs refers to the relative novelty of the procedure and that it's yet to attract a body of authoritative UK case law about its operation, although there's significant Canadian jurisprudence.
Sorry, give me the page.
Oh, I'm so sorry, my Lord, it's page 156. And he observes it's necessary to set the bones of the statutory structure in its context for that reason, because these are early days, essentially. And that's precisely the point which my Lord Justice Green made in relation to the guide. You know, one has to tread carefully because these are early days. At paragraph 20, Lord Briggs then said this collective proceeding was introduced in 2 stages. The first was in the Enterprise Act 2002, but it only permitted opt-in proceedings and was unsuccessful. So that's the verdict on what went before. That's what happened before opt-out. It didn't work. The second was in the Consumer Rights Act 2015. If I could ask your lordships just to read to the end of that paragraph 20.
What is he citing this for? I mean, you can cite legislative history, because if you apply Lord Bingham in Quinterval, you have to know what it is when you introduce a legislation, what is the gap that you're plugging? So you look at the legislative history. This is slightly different to using this as a guide to interpretation. You would never use a CP, a consultation paper. You might use a final report, which then led to a bill. But this is really legislative history to try and determine what it is that the Consumer Rights Act was plugging as a gap.
Well, I think I can't do better than rely on his own words, which are to set the statutory structure in its context.
What does that mean?
Well, I think it's fair to say it feeds into his understanding and his articulation of the statutory objective. So it may be somewhat
Is it any more than that, really? I mean, he says in that sentence at the end of 19, you're quite right, as will appear, it will be necessary to set the bones of the statutory structure in its context, as a part, albeit specialised, the UK civil and tribunal procedure. What he's then doing is saying, well, this is the purpose of the statutory scheme, by reference to the history.
That's right. That's right. So it informs his crystallisation of the statutory objective.
Yeah.
And that's informed by the fact that the opt-in, the days of opt-in only, were a failure.
Yeah.
And his lordship regarded that as worthy of note. And then he ends, at the end of paragraph 20, by referring to the proposal, which was to introduce an opt-out collective actions regime. So it wasn't to introduce a collective actions regime. The emphasis is on opt-out collective actions regime for consumers and businesses. Now, Lord Briggs obviously wasn't looking at the opt-out question, because that wasn't challenged in Merrick's. Certification was challenged. So I will just briefly go back to those consultation documents, looking at them through the prism of the opt-out question. And a handful of the key paragraphs were rather glossed over this morning. So I just want your lordship to have those.
What does it boil down to at the end of the day? Is it more than, if we were to, let's take an example, we have to look at the word damages, we have to look at the word distribution, and if assuming we apply a purposive construction, and we identify the purpose as being to maximise properly and respecting rights of defence and so on, access to justice, does it lead to anything more than that? Given that we have a choice between opt-out and opt-in, in a sense why that's there is neither here nor there, but we're looking at purposive construction designed to facilitate access to justice. Where does this all end up in terms of a guiding principle for us?
Well, the reason to go to these provisions is to respond to Miss Ford's submission that the essential error of law, if I could put it that way, that she's alleging is a misconstruction of practicability. And I want to respond on that point by reference to what does it mean for an an opt-in procedure actually to be practical. The consultation documents tell you very clearly it's not often practicable, and they say in terms, and you've seen one of those passages, small business claims on behalf of a small number of businesses for high values might be very well suited to the opt-in procedure. There's no suggestion in the consultation documents that opt-in is suitable for anything wider than that. And Ms Ford made some rather sweeping submissions on this. She said this is essentially turning matters on its head and will denude the opt-in proceeding of any utility. That's simply not the case, because it was never there for that. Actually, what was really revolutionary about the consultation which then led up to the reform was the introduction of the opt-out procedure. That's what was new, and because we had opt-in and it hadn't worked. I also want to bring out the theme of the lack of equivalence between joining an action and taking distribution of monies, and the fact that the opt-out procedure has that in mind. It's baked in, it's enshrined in the approach. But I think I can deal with these points very briefly as I go to these documents. So the first is the 2008 report by the Civil Justice Council. That's in supplementary bundle, tab 6, page 118, paragraph 2. What's said there is that while there are a number of mechanisms, such as GLOs, this is back in 2008, there remains an access to justice gap. The denial of effective access to justice, as demonstrated by a particular study, and by the failure of the follow-on competition law regime to produce more than one action, which you've now heard a lot about, which left, as a consequence of the barriers to entry created by its opt-in nature, vast numbers of those who'd suffered actionable detriment uncompensated. And it said that provides strong support for the conclusion that citizens in England are not being fairly served by the present procedural mechanisms, including the opt-in mechanism. And then going forward to paragraph 22. If I could just ask your lordships to read that paragraph, that's on page 129. Ms Ford took you to the first two sentences, but not the rest of the paragraph. What I wanted to draw out there is the reference to the burden and strategic vulnerability associated with the opt-in process. That's not just about contacting people. I'd suggest that that's actually another way of putting the convertibility problem. Strategic vulnerability. If I may then move forward to the April 2012 paper by the Department of Business, Innovation and Skills, which you've seen, and that's the one cited by Lord Briggs, proposing the opt-out regime. Paragraph 5.4 at page 151. You see yet another reference to the Which case at the beginning of 5.4. noting that fewer than 0.1% of those affected signed up to the action. There have been no other cases brought, and which has made it clear that it considers the system must be changed to one that is opt-out. And then you see para 5.5 setting out the views of which got to have opt-out systems for competition redress. The only real practical way to get over this is to introduce an opt-out system. And then if I could ask your lordships to move to page 155. Now really paragraphs 5.18 to 5.23 are the key passages in this paper, and I'd recommend them to your lordships for your note. But at paragraph 5.18, which notes that the single biggest hurdle is the requirement to name claimants on the claim form. That's not contactability. That's the issue there, is asking people to step forward to be named litigants. At 5.19, refers to very low levels of participation in the pre-existing opt-in collective regime and under the GLO's regime in the High Court, where levels of participation are 50% or lower. By contrast, it notes that the median participation rates in opt-out cases in other legal systems where evidence is available have been between 87 and over 99%. So that's the evidence. Then if I could ask your lordships to move forward to page 157, paragraph 5.26. The report there refers to two principal advantages of opt-outs. And the first one is, it's the type of regime that's most likely to deliver redress to most of those wronged. And here comes the important bit. Claimants only have to step forward after the judgment and amount of award are decided, and the publicity of winning an award likely to generate publicity to make potential claimants aware. And then again, you see the evidence on participation rates. So the point I want to draw out from that is the premise, the organising principle of an opt-out regime is that class members will do what is necessary at the end of the day to collect their share of the damages, while not having to act at the outset. So that goes to Ms Ford's submission on that point. That's the premise. And then finally, at the following tab, page 176, paragraph 5.12, equally, though, it's very clear that the current system of collective redress does not work. Consumers are not currently getting redress for breaches of competition law. It appears unlikely that simply tinkering with the opt-in system would deliver the desired access to justice. Consumer groups have been clear that they would not take another case under the opt-in system, and bodies such as the Law Society of England and Wales have said that an opt-out regime is essential if consumer cases are to be brought successfully. It's also clear, as indicated in the consultation, there are some cases that could only ever be brought on an opt-out basis in practice. As I said, this is one of them. At 5.14 over the page, you see the government's decision to introduce a limited opt-out collective actions regime with safeguards. And then, my lords, you've seen this example in another of the documents. I won't take you to that one. The government does recognise at 5.15 that there may be some collective actions which would be more appropriately brought on an opt-in basis, such as a case brought by a small number of businesses, all of whom are clearly identifiable, a small number of businesses. very different type of case. That, I'd suggest, is the paradigm opt-in case. The view that opt-in is best suited, is apt for those kinds of cases, does not denude the opt-in proceeding of its effectiveness. That's really what it's there for. My lords, that's all I was going to say on the consultation documents. You see they're peppered throughout with references to the failure of the pre-existing opt-in regime, its failure to stimulate collective actions, and the need for an opt-out framework to breathe new life by removing these barriers to access to justice. My lords, as you know, my submission is that the deficiencies of opt-in regimes have now been recognised and endorsed at the very highest level in Lloyd Google, judgment of 5 members of the Supreme Court. Now, Ms Ford put it to you that Lloyd is not in any way considering the structure of the provisions your lordships are concerned with today. But that's not the case. I do accept, of course, the relevant passages are obiter, but they are powerful. As your lordships will have seen, this judgment postdates the tribunal's judgment. It's at tab 11 of the authorities bundle, page... wrong bundle. Page 282. Now, although it concerns the Data Protection Act, competition law regimes feature early on in the judgment. First at paragraph 3, which refers to the 2008 Civil Justice Council's report, which I just took your lordships to. It refers to the fact that the government rejected an across-the-board opt-in, but instead it was confined to competition law. That's at paragraph 4 of Lord Legate's judgment. The only sector. Lord Legate then turns back to collective redress at page 286, and he begins at paragraph 24 by describing the group litigation orders procedure under CPR 1911, and then over the page 287, at paragraph 25, second sentence, he turns to what he describes as the drawback of the group action procedure, which is that it's an opt-in approach. In other words, claimants must take active steps to join the group. Then in the remainder of the paragraph, he talks about the administrative costs of that, rather similar to the points your lordships were putting to me a few minutes ago. Then at paragraph 26, relevantly for the purposes of my submission, Lord Legate then turns to the problem of low participation rates in opt-out proceedings. And he says the problems include lack of awareness of the opportunity to join the litigation. It was said, I've skated over that, except that's one of the points put. And the natural human tendency to do nothing when faced with a choice which requires positive action. And then the remainder of the wording there is important, particularly if there's no immediate benefit to be gained and the consequences are uncertain and not easy to understand. So again, that goes directly to the point about different incentives at the stage of joining a case and accepting a payment. As the New Zealand Court of Appeal has recently said of opt-in class actions, whichever approach is adopted, many class members are likely to fail to take any positive action for a range of reasons that have nothing at all to do with an assessment of whether or not it's in their interest to participate, Some will not receive the relevant notice, others won't understand it, or will have difficulty understanding what action they're required to take and completing any relevant form, or will be unsure or hesitant about what to do and will do nothing. Even where a class member considers it's in their interest to participate, the significance of inertia in human affairs should not be underestimated. Now, it's only then, and this is a point which Ms Ford made to you, which I must respond to. At that point, he says a further factor is that individual losses may be very small, even if aggregate it's very large. So the need to prove individual loss is a problem. And it's quite right that that's a problem that we don't fortunately have in the competition law regime, given the ability to award aggregate damages. But he says that's a further factor, that's para 28. Para 27 is about inertia and the other problems. So when Ms Ford says Lloyd Google is irrelevant because it's about aggregate damages, it's not the case. Paragraph 28 is about aggregate damages. Then at paragraph 29 and 30, he turns to the collective proceedings regime in the tribunal. And he notes two particular features of the regime. And the first one is that one can now have opt-out proceedings where persons may then have a claim brought on their behalf without taking any affirmative step, potentially without even knowing the existence of the proceedings. And then at para 31, he turns back to the fact that there's no need to prove individual loss in the tribunal. So that's the point I've already mentioned. So clearly, read holistically, he's saying there's a real problem with opt-in, and look what we have in the Competition Appeal Tribunal. We don't have these problems because of the new opt-out regime. And that's an answer to the problems of inertia and so on. So it's a powerful endorsement of the proposition that opt-in proceedings are an ill-suited mechanism for large classes of consumers. One last document I'd like to take your lordship through. I misled you by saying I had nothing more on the consultation documents. Just very briefly to respond to a point Ms Ford made. She took you to tab 10.
It's quite interesting, actually, sorry, before you leave, Lloyd, I was just looking at the end of 32. It's not, this is really on the second ground, but so we're going to have to come back to it. He makes the point there that in an appropriate case, it may be impractical or disproportionate to distribute the damages by reference to individual loss. It may be actually easier to make an equal division amongst the members of the class, so they all get the same amount of money. And that seems, at least in part, to address Ms Ford's point about the nature of the damages that are being awarded, because it's focusing on the fact that damages is the aggregate amount that's recovered. How you distribute it thereafter may in fact not necessarily comply with, strictly speaking, with the compensatory principle. It may just be practical reality because you've got 2.3 million people to pay.
I'm grateful for that. And that's actually, there are two interesting points to say in response to that. One is that Sir Peter Roth in the Competition Appeal Tribunal has picked up that point in, it's either McLaren or Gutman, I now can't recall, and says, well, this is now endorsed by the Supreme Court. This is one of the benefits of what can be done in the tribunal. There needn't be a reflection of individual loss. That's, you know, like opt-out, it's pretty radical stuff, actually.
It's the reference, I think, to broad axes, isn't it?
Precisely.
No need for precision. You apply a practical, pragmatic, broad axe to do justice.
This is... it's obviously one of the hot topics at the moment in collective
Broad
claims.
access,
It's sort of
yes.
quite exciting that one is freed from the constraints of quantification. But that rather steps outside the issues for today, but fascinating though it is.
We're all suffering from wounds of the broad action one or another, Ms. Griceberg.
But more relevantly to this appeal, there is a conflation, I think, in Ms Ford's submission on damages and distribution, which my Lord Justice Green commented on, and I will come back to this. I will take you to the rules, because there is a clear distinction between the award of aggregate damages and then what's done with those damages to distribute them to the class. It's Rule 92 versus Rule 93. And the point I was just going to address your lordships on was coming back to the draft Consumer Rights Bill. Ms Ford took you to page 239, which is at tab 10 of that document. It's the last sentence, which refers to the greatest barrier is reaching consumers who've suffered detriment.
Which page, sorry?
Page 2, sorry, my lord, I think I gave a wrong reference. It's page 252.
252.
Para 273. Now, the ability to reach consumers, in my submission, goes beyond mere contactability. Reaching consumers connotes some form of engagement. So we say this supports our case. Simply contacting them doesn't ensure participation. Yes, I'm grateful to Mr Grubeck, who has given me the reference to the aggregate damages point citing Lloyd, but this is really more for academic interest. It's paragraph 26 of the McLaren judgment, which is at A13335. My lords, I was proposing to limit myself when it comes to the guide to just a few remarks. As your lordships have had an opportunity to see paragraph 6.39, which is at page 38, tab 5. The guide's of course not binding. So the view expressed there that there's a general preference doesn't form part of the statutory scheme. Your lordships have already observed it's not in the rules or the Competition Act. But my submission is that in any event, this additional gloss on the wording of Rule 79.3 of a general preference doesn't come to much, because the guide correctly observes that when assessing if opt-in proceedings would be practicable, the tribunal is required by the rules to consider all the circumstances and to consider whether opt-in proceedings would be workable and in the interests of justice. BT's case, that there is one single point which is fully dispositive, the fact that BT can contact some or perhaps most of the customers in the class, is not consistent with the rules or the explanation given in the guide, or the discretion, the nature of the discretion, which is to look at all the circumstances. It's true that the guide refers to contactability by way of example, but that's all. One needs to look at all the circumstances. However, bearing in mind Lord Legate's criticisms of opt-in procedures, which are, as your lordship observed, sense, really, as to whether one might jump into a heavy piece of litigation that's not understood. My submission is that one might consider the notion of a general preference for opt-in where practical as not of great utility in the context of large consumer actions for low individual amounts, where opt-in proceedings are unlikely to be practicable for all the reasons that have been ventilated today. That's not what the consultation documents say. Contrast that with a claim on behalf of a small number of businesses for individual high values.
Yeah.
My Lords, that concludes my submissions on the legal framework for the CATS assessment under Rule 79(3). If I could turn to the second part of my submissions, I'd then like to take your Lordships to the Tribunal's judgment, the parts dealing with the Rule 79(3) assessment, if I may, and that's at Core Bundle, page 375, tab 13. And the first 4 paragraphs, which your Lordships have already looked at, are important. So if I may just take your Lordships to them.
Yeah.
If I could begin with paragraph 111 on page 376. Ms Ford took you to that paragraph. That's where the Tribunal summarises BT's overarching point that class members can be identified and contacted. And at paragraph 112, the Tribunal cited Mr Le Patourel's response. There are essentially 3 elements there. That there is a real difference between the option to join a legal action at the outset and claiming a damages entitlement later once the case has been won. That's the first sentence. Secondly, that's especially the case with a demographic of at least most of the potential claimants here, where there may well be a reluctance to sign up to a legal action, where the risks and complexities will have to be explained to them, and that this scenario differs from that in which they're simply asked to collect a defined amount at the end. And then the third point, sorry, my Lords, I just actually want to pause after the second point. That is a useful hook. The reference to the demographic, the demographic is described earlier on in the judgment at paragraphs 11 to 13 in excerpts from the Ofcom review. In short, as you know, the voice-only subclass has a high proportion of elderly people who have stayed with BT as their landline provider for many years. And legacy customers across both subclasses who have never switched deals. So there is an illustration of the inertia demonstrated by this class. This is not a key target audience for taking proactive steps. And that's a feature that puts them, it's a defining feature of the members of the class. They haven't switched to other deals, bundles. And also that they're in DE socio-economic group in large part. Now, the Independent Communications Consumers Panel, that's a statutory expert panel, described them to Ofcom as disempowered consumers. And I'll just give your Lordships the reference. That's at Mr Le Patourel's first statement, paragraph 39. And that's in the supplementary bundle, tab 1, page 15. just a diversion as to what the tribunal is referring to when it refers to this demographic at para 112. And then the third point made in this passage is that distribution might not require active participation if there's direct credit, giving the example given by the tribunal in the Gutman case. Then we turn to paragraph 114 over the page. Now, this is the key paragraph which crystallises the tribunal's reasoning on the opt-out question. It's right that it begins by summarising the class representative's contention that there's little prospect of these 2.3 million customers being sufficiently proactive to opt in. And then the second sentence, the claim is a technical one. It is also correct that paragraph 6.39 of the guide does presuppose that individual customers will have conducted their own assessment of the strength of the case before opting in. That seems unlikely here. So it's very clear that in this paragraph, the tribunal is giving its own views, its judgment. So it's moved from capturing the submissions of the class representative to endorsing them. It is also correct that. So it's clearly endorsing them. That passage concludes, nonetheless, in our judgment, the position at this stage is not at all the same as at the distribution stage for the reasons already given. My Lords, you debated this with Miss Ford. My submission is that's plainly a reference to paragraph 112, the reasons there. So it's in endorsing. So that is the crystallisation of the finding on opt-out.
Well, it may be that the tribunal might have expressed itself with more clarity in distinguishing between council's submissions and its reasons, but most of 112, as I read it, is the tribunal expressing its own views, albeit they accord with what was submitted. The second two sentences, really from the first sentence onwards, it may have been what council was submitting as well, but it's clearly being endorsed by the tribunal, and that's why they say in the third sentence, indeed, and as canvassed with council.
Quite right.
Saying, well, this point is clearly a correct point because it's borne out by the point we made.
Yes, it's an endorsement.
Yeah.
And that makes sense of 114,
Yeah.
which incorporates 112, essentially. I can take the remaining passages more swiftly. At 115, the tribunal accepts the class representative submission that low uptake rates for an opt-in claim mean that it would be unlikely to attract third-party funding, so any prospect of a claim would be extinguished. Uh, 116, the tribunal didn't attach weight to the submission on brand loyalty. 117 is where the tribunal turns to BT's argument that the tribunal has no jurisdiction to award damages by way of account credit because of the wording of Rule 93. You've heard Miss Ford on that. I'll return to the substance of the point in my submissions, but here, halfway down the paragraph at 377, para 117, for our part, we do not accept the position is as clear as that. So there's no finding, no determination of the point. Similar language at 118, it would be extremely odd if Rule 93.2, interpreted in a common sense way, would prevent this obvious way of compensating customers who have won. Now, I would, in my submission, emphasise the correctness of that, but at the same time, it's clearly not a point that's been decided. The tribunal thinks it's an odd submission for BT to be making, counterintuitive. And the tribunal then rejects BT's submission that the discretionary power in Rule 93.3. Now, all that Rule 93.3 does, and we can come back to look at that, is to provide a date by which represented persons shall claim their entitlement BT says, well, that requires positive steps. The tribunal rejects that submission where a more efficient means of compensation exists. It's simply a discretionary right for the CPO order to provide a date by which representative person shall claim their entitlement. It's not saying anything about the type of steps they have to take. And then at paragraph 119, the tribunal rejects BT's argument that distribution couldn't be affected by direct credit because it wasn't in the notice and administration plan, given essentially that it's a living document, which is well accepted. We're all on a learning curve. And the final sentence of paragraph 119 is significant. So they reject BT's point and then say, in any event, this point does not overcome the difference in principle between a relevant customer engaging at the outset as opposed to the end stage when informed that they are entitled to compensation. So whatever BT is saying about what can and can't be done at distribution is not really to the point, because the key point is that at 119B, difference in principle. 120 is similarly significant. Here, the tribunal explains that it would not have reached any different conclusion in relation to SPCs, split purchase customers, the ones that buy broadband but not as a bundle. And those SPCs are customers who have higher levels of engagement than the voice-only subclass. In the last sentence, the tribunal says, a relatively higher level of customer engagement in the context of the service being provided does not by itself translate into a willingness to embark on litigation and the initial administrative process, as opposed to simply collecting at the end of it. So the reason I say this is important, that makes clear that the disadvantages suffered by many in the voice-only class is not regarded by the tribunal as a necessary condition for the tribunal's endorsement of the opt-out proceeding. Those characteristics of the voice-only class certainly make the need for an opt-out procedure more acute here, but the tribunal's assessment wasn't contingent upon it. So it's the broader point about incentives. And in that sense, this judgment, which predated Lloyd Google, is on all fours with Lord Legate's disparagement of opt-in claims as a general proposition for large consumer actions, because it's a reference, again, to the human bias to inertia. Paragraphs 121 to 123 addresses BT's claim that the opt-in procedure would allow for the identification of business customers for the purposes of their pass-on defence. But essentially the tribunal held that's not a consideration of sufficient weight to alter the tribunal's assessment. Moreover, BT hadn't suggested otherwise. Ms Ford had merely suggested it's something that goes into the mix. Paragraph 124, I'll come back to when I deal with strength of the claims. I know your lordships have spent some time looking at that one. So to conclude on the judgment, what we have, notwithstanding some fair criticisms that have been made of the reasoning, is a careful assessment of the class representative's reasons for asking the tribunal to certify opt-out proceedings and of the opposing points advanced by BT. You see the various factors are weighed in the balance, some are accepted and weight attributed to them, others are rejected. That's precisely the reasoned multifactorial assessment which the tribunal is required to conduct. And the tribunal makes clear that its overall conclusion, what Lord Briggs refers to as its value judgment, that opt-out proceedings are appropriate, was principally driven by its assessment that uptake rates for an opt-in action would be too low for the proceedings to be viable and attract funding. That is the operative part of the reasoning. It's the ratio. Now, if I may turn to the third and last part of my submissions, addressing BT's various criticisms of the Tribunal's assessment, dealing with the three grounds in turn. So the first ground is that the Tribunal misdirected itself in law under Rule 79.3 because it didn't understand, it failed to understand that opt-in proceedings were practicable. BT's 4 points, which I'll respond to, somewhat reordered, are that the reasoned multifactorial assessment described by Lord Briggs in Merricks applies to suitability, not to Rule 79.3 or the concept of practicability. Ms Ford did refer to that this morning, so I think I do still need to respond to it briefly, although, to be fair, I don't think it was a point that was pressed. Secondly, the opt-in proceedings were clearly practicable because of the contactability point, and Ms Ford says that the primary obstacle to opt-in proceedings is the inability to identify those who've suffered loss, and that the Tribunal's opposite finding frustrates the integrity of the collective regime, which is a failure of duty by the Tribunal. Third, that the CAT was wrong to take account of third-party funding, which has emasculated the assessment of practicability. And fourth, that it was untenable for the Tribunal to find a difference in principle between opting in and taking distribution. Taking each in turn, on the question of statutory construction of the discretion, so what's the test that the Tribunal had to apply? Well, I've taken your lordships to the identical formulations used in the 3 sub-paragraphs of Rule 79, the formulations of all matters it thinks fit and having regard to all the circumstances. In the light of Merricks, there can't be any doubt that the Tribunal has an unfettered discretion to decide on what's relevant and on that basis reach an overall conclusion on opt-out. BT objects to giving the same formulations in the same rule the same meaning, but she hasn't offered a different construction or alternative approach. It's not entirely clear what the objection is. BT's second and central point on contactability. I've shown you that the Tribunal listened to the arguments, weighed up the factors and arrived at its judgment on the non-viability of opt-in proceedings. And you have BT's point, it disagrees because of the ability to contact some of the class. Now, the Tribunal, you saw, took that point into account. It features in the judgment, but ultimately it didn't alter the Tribunal's assessment. Even if BT could write to them, bearing in mind that whole subclass doesn't have broadband and it has to be postal, too few class members would engage with the process, noting its highly technical nature. Now, BT disagrees with the Tribunal's exercise of its discretion. According to BT, this is the only point that should have been treated as decisive, and all the others should have been disregarded. But as the Tribunal said itself in the Permission to Appeal judgment, that's just a disagreement with the Tribunal's exercise of its judgment following the multifactorial assessment. It doesn't contain any error of law or any grounds for interfering with the Tribunal's assessment. Now, BT then advances various points to elevate this objection into an error of law. It says that the Tribunal applied a mistaken concept of practicability. Well, it's hard to see how that can be right, because the Tribunal asked itself whether a sufficient number of class members would join opt-in proceedings for them to be viable and attract funding. That was the question. Answered it in the negative. So the Tribunal didn't misconstrue the plain meaning of practicability, understood what practicability meant, it just didn't think that opt-in proceedings were practicable in these circumstances. Second, BT's claim that the primary obstacle to opt-in proceedings is contactability, well, that's the fiction on which this appeal is based. It can pose a barrier, but there are other important barriers such as inertia. I've shown you the consultation documents, and Lord Legate's findings on that, observations. Third, it should be noted that even on BT's case, some class members won't be contacted and will fall through the cracks. Former customers who've changed address, and if they don't have broadband, it'll be difficult to get to them, and personal representatives of the deceased. And just for your note, BT's defence contains a general denial of the allegation that BT can contact all class members. That's defence paragraph 37, core bundle, tab 10, page 304. Fourth, the tribunal's rejection of the opt-in basis did not breach its duty to uphold the integrity of the regime. The reverse is the case. The evident statutory purpose, as I showed your lordships, is to facilitate, not impede, the vindication of the rights of consumers who've been victim of competition law violations. The tribunal's decision to certify on an opt-out basis furthers that statutory purpose because, simply put, it lowers the barriers to accessing justice for these class members. BT's case on opt-in would raise them. That's why the opt-out regime was introduced. It's worth remembering the opt-in proceedings here, what would that mean? It would involve asking over 1 million individuals in the voice-only subclass to opt in without the benefit of broadband. Mr Le Patourel put in evidence on this point in his first statement at paragraph 31C, which is a supplementary bundle, tab 1, page 12. And asking people who have difficulties navigating complex markets and identifying tariffs which best meet their needs to take a decision to opt into highly technical litigation and take the necessary steps and do it all offline is just unrealistic. Now, Ms Ford criticised the tribunal for blindly accepting Mr Le Patourel's evidence on this. Well, Mr Le Patourel did put in extensive evidence on these points. There's no need to go there, but just for your note, in his second statement, at paragraph 33 and following, which is a supplementary bundle, tab 3, page 51, he went into some detail as to why opt-in would be unrealistic. BT did not bring forward any rebuttal evidence, so that evidence went uncontested, and he was not called for cross-examination. So it's not right to say that the tribunal blindly accepted it, saw the evidence, exercised its judgment on the point. Now, one can contrast this set of facts, this fact pattern, with that in the McLaren case that Ms Ford took you to, which, as my Lord the Chancellor observed, the argument around opt-in involved a group of around 45 large business purchasers. That's clear at paragraph 158, which Ms Ford took you to. Couldn't be more different from this class of 2.3 million consumers, some facing challenges. And the tribunal made the point that these consumers are unlikely to be in a position to assess the merits, which is assumed to be the case for opt-in proceedings. My lords, then, if I may move on to BT's third point on funding. Funding is often described as the lifeblood of the collective regime. Professor Zuckerman, in the article in the bundle, refers to it as the petrol which drives the collective vehicle. Whichever is your metaphor of choice, it's absolutely central to the operation of the regime. And that was reflected in the Court of Appeal's judgment in Merricks at paragraph 60. There's no need to turn it up, but the Court of Appeal observed that the power to bring collective proceedings was obviously intended to facilitate a means of redress which could attract and be facilitated by litigation funding. Without funding, the statutory objective simply can't be achieved, and class members will be denied a trial by the only procedure open to them. So given the breadth of the Rule 79.3 discretion, there's no grounds for excluding funding from consideration as Ms Ford would have it.
It's referred to in Rule 4. I mean, funding is one of the matters which have to be taken account of. I mean, it refers to the party's means or relative means, but access to litigation funding is a factor, which under the general principles I think is relevant.
Yeah, so it's not an oddity of the collective regime, but obviously becomes critical for these claims to get off the ground. So it's right.
So, yes, Rule 4.2c, the financial position of each party is one of the matters which is relevant to the exercise of discretion.
Yes, I'm very grateful to your lordship for that. It's quite right. So it's a much broader principle there. So it's incorrect to say that the tribunal has to close its mind to it under 79.3. Now, I just want to respond to Ms Ford's submission that taking account of funding emasculates the assessment of practicability. What she seemed to be saying is that it allows the outcome to be dictated by the funder's expressed preference. That's not the case. It's not about funder preference. As my Lord Justice Phillips observed, it can't be right that it's irrelevant, but it doesn't dictate the outcome. In other words, on these facts here, the tribunal considered the class representative submission that uptake would be too low to attract third-party funding. But the tribunal considered it and accepted it based on its assessment of the facts, its assessment that not many people would opt in. In a different case, the tribunal might say, we're not persuaded that funding wouldn't be available for opt-in proceedings. For example, the small business claim the hypothetical paradigm for opt-ins.
It may be less problematic in follow-on claims with largish companies where there's established liability and it's obvious that sums, again, fairly considerable sums will be paid. The question is what and how.
Particularly if the claimants are businesses, one might think. And again, I would certainly hesitate about articulating universal approaches to any of this because the nature of the exercise is so highly fact sensitive. So I would reject each of Ms Ford's submissions which are along the lines of this means that you'd never have an opt-in. It will come down to the facts. But it's right that here funding is critical.
Probably.
Well, if you're right as to the width of the discretion that's afforded by Rule 79.3, with its use of matters such as the tribunal may take into account all matters it thinks fit, and then it's having regard to all the circumstances, none of which is limited by the rule or by the statute, then what effect a decision on given facts in this case might have in subsequent cases is neither here nor there. I mean, if there's a deleterious effect that needs to be remedied at some later stage by the change in the rules or the change in the statute, well, that's for the cat on the one hand and the Parliament on the other.
That's quite right. And that's why I say, I don't press the point, but I say that the wording of the guide, insofar as it refers to a general preference, is maybe not as helpful as one might think. It's not technically wrong.
Well, it might be thought that with the benefits, as I said earlier on, of 7 years of experience, the guide might be written in a different way today.
quite, and if helpful, we do have the preface to the guide which makes the point that Lord Justice Green made. We're all on a learning curve, but I suspect that's right, Your Lordship. It's not terribly happily worded because it gives the wrong impression.
The preface makes clear that the guide, so far as collective actions are concerned, is, if you like, a president's best view of what might be the trends and might be the considerations which are relevant in the future, but with a very strong dollop of caution. You know, the CAT must evolve its own thinking on this. And it's unfair to criticise the guide, which was drafted in 2015, without any experience at all.
Quite without the benefit of crystal ball. Having said that, it does strike one as a little odd, given the way in which the objectives were expressed in the consultation documents and the emphasis on the shiny new procedure being the opt-out procedure, and the acknowledgement, and I took you to that, well, there's still a role for opt-in, but it's not really the radical change that the reform is bringing about, that's opt-out. It's also, my Lord, notable, and I counted, and we can provide a list, that of the 16 live collective actions in the tribunal, 15 are opt-out. The opt-in claim is in the trucks litigation, and it's on behalf of businesses, not consumers. And as we saw in McLaren, the argument was being made in relation to businesses. All of the consumer claims are brought on an opt-out basis. So again, yes, with the benefit of hindsight, it's just interesting to note. I'm then on to BT's fourth argument on this ground, which is the tribunal's finding that there's this difference in principle between opting in at the outset and collecting damages. BT says is untenable and undermines the regime. 2 short points. I've shown you paragraph 5.26 of the April 2012 government paper, which I described as the organising principle of opt-out proceedings. No need to step forward until after damages are available. So far from undermining the regime, this is on all fours with it. And the second point is, even if the form filling did look the same at each stage, and I haven't yet got to distribution, that misses the point, because it's the difference in incentives at each stage that really matters, and that's what's explained by Lord Leggett. And it's not just the earlier stage, it's what they're being asked to do. The difference between being asked to join something one doesn't really understand and collecting some money. So there's a world of difference, and that is hardly a radical proposition. The same point was crisply expressed by Sir Peter Roth in Gutman. If I might just briefly show you that, it's already come up there. That's at page 272 of the Authorities Bundle, tab 10.
Sorry, I missed the page number.
Sorry, 272. The tribunal said there the small amount of estimated individual recovery means that very few persons would seek to opt in, and the large size of the class in each action would make opt-in proceedings very difficult to manage. That's the point I had wanted to show your lordships earlier. We should add that we were not impressed by the respondent's argument that if few class members would choose to opt in, that demonstrates that few would submit a claim after an award of aggregate damages. Participating in potentially lengthy and uncertain litigation from the outset is a very different proposition from claiming even a modest payment for which the claimant is eligible to apply from an existing fund. So that puts the point very crisply. My Lords, if I might turn to distribution. Now, BT says it was an error of law for the tribunal to consider that distribution might be achieved without active participation. And BT makes three arguments under this heading. The first is that direct credit is precluded in a claim for damages. The second is that Rule 93(1) precludes direct credit because payment must be made to the class representative or some other person. And 93(3) mandates that class members must take active steps to receive their share of distribution. I have 5 short points by way of response. First one is this ground of appeal is essentially a sideshow. The decisive consideration for the tribunal was the difference in principle between engaging at the outset and collecting damages. So that finding stands even if positive steps are required at distribution. And clearly, positive steps will be required, at least by some represented persons, if there's an award of damages, such as former customers and personal representatives. Secondly, the point is raised by BT prematurely. Whether class members will need to take positive steps to collect monies owed arises for determination further down the line. It's a debate for another day. And that's precisely why the CAT didn't determine it. Now, if I might
It's true the CAT did take it into account because of the question of without having the active involvement of the customers. So if there's an account credit.
It did. It addressed BT's arguments on this point, but it made clear, and I think it was paragraph 119B, that in any event, it didn't address the principled objection of a difference between joining.
You say the ratio for the if that's the right word.
Yes.
Probably isn't, for the relevant exercise of the discretion, is the point you identified, which is that there's a difference in principle between participation at the outset and collecting your money after the event. And if that's right, well then that's an end of the point. And this is just an additional reason that would justify that conclusion. But if they're right in that conclusion, even if they're wrong on this one, it doesn't matter.
Doesn't matter. And that's not just my construction of the matter, that's what the tribunal says in its judgment. My Lords, if I could ask you to turn up Rule 92 and 93, which is page 68 of the Authorities Bundle, tab 6. Sorry, perhaps it's not the... Now, the reason why I say it's premature, let me just show your Lordships the relevant provisions. Now, your Lordships asked whether there's a difference here between awarding damages and distributing damages, and there is. I notice as I take you to these provisions that the headings aren't very helpful in the rules. But Rule 93(1), which you're now very familiar with, provides for the award of damages in opt-out collective proceedings. And that's, so let's assume it's an award of aggregate damages. The tribunal can order under Rule 93(1) that award is made to the class representative or some other person, such as a claims administrator, which you'll have seen we suggested. So that's the award of aggregate damages. Rule 93 does not provide for distribution. That's set out at Rule 92. Where the tribunal makes an aggregate award of damages, it shall give directions for the assessment of the amount that may be claimed by individual represented persons out of that award. Then subparagraph 2 gives examples of how distribution might be affected. So this is coming back to the interesting point about whether there needs to be a reflection of individual loss or not. And then, importantly, subparagraph 3, the class representative shall give notice to represented persons in such manner as the tribunal directs of any hearing to determine what directions should be given in accordance with paragraph 1. And any represented person may apply to the tribunal to make submissions, either in writing or orally at the hearing. So the order is slightly odd and the heading is a little odd, because what you have is the award of aggregate damages under Rule 93, and then you go back to Rule 92, and the tribunal can have a hearing to determine how distribution is affected. So I hope that helps on my Lord Justice Green's question there. Now, that means the statutory scheme is deliberately structured in a way that means distribution is determined after an award of aggregate damages is made, and represented persons can make submissions at that hearing. Now, Lord Briggs explained the purpose of this provision in Merrick's at paragraph 77. But rather than take you to Merrick's, it's that passage is captured in Gutman, which is at page 268 of the authorities bundle, tab 10. It's just a more convenient place to show you the passage from Merrick's. So in Merrick's, you have the reference there to the radical alteration of the compensatory principle that we competition lawyers are all quite excited about. And then addressing the method of distribution of aggregate damages, Lord Briggs stated at paragraph 77, whilst there may be many cases in which some approximation towards individual loss may be achieved by a proposed distribution method, there will be some where the mechanics will be likely to be so difficult and disproportionate, for example, because of the modest amounts likely to be recovered by individuals in a large class, that some other method may be more reasonable, fair, and therefore more just. For that purpose, the statutory scheme provides scope for members within the class to be heard about the proposed distribution method. That's the provision I've just shown you. In many cases, the selection of the fairest method will best be left until the size of the class and the amount of the aggregate damages are known. And the reason I took you to this judgment is Sir Peter Roth then comments, although the tribunal can have regard to the proposed method of distribution at the certification stage, it must do so in light of this governing principle. So this is the governing principle for distribution.
When I first read that, I wondered whether they were really talking about how you divide it. Let's assume the pie is 100, and you've got 150 different classes of individual or customer within the class, and the court and the tribunal simply says, well, that's just ridiculous. We're not going to create 150 categories. We're going to divide it into broad acts, 5 categories. It doesn't necessarily tell you, I'm sure this is what Ms. Ford would say, that they don't get a sum of money, although they are talking in broad terms about method. So I wasn't quite certain in my own mind whether this was just how you divide up awards of damages, or whether what was being referred to here was slightly broader and did determine different types of distribution. It's slightly ambiguous. It's flowing from the aggregated damages point, which is really about making sure that you don't have to use too fine a toothpick to divide up the sums as between people who may be very, very, very different in their nature.
I accept that, my lord, but Rule 92 does refer to directions to the method by which such amounts are to be quantified, so on. as you've observed, the tribunal has very wide discretion in these
I think
matters.
that's the point, because there would be many cases where the normal compensatory mechanism will be used, and where you're just dividing up a pie in a much more pragmatic way than you would in accordance with traditional common law principles. So it's inevitable you're going to have the tribunal having an express power to do a rough and ready quantification of an actual sum, fungible in nature, to be paid. We're talking about a different category of case where there is an account and a possibility of an account credit, which won't arise in every case.
But the point I'm drawing out from this is that after you have the aggregate damages award, which is clearly to be made to the class representative or some other person, the tribunal then pauses, asks the class representative to notify the class that this is going to happen, and then the class has an opportunity to be heard.
Yes.
Now, it seems to me that in a case such as this, class members might have a view on whether they want to receive monies by direct credit.
Yes.
And if they do, this provision allows them to be heard.
Yes. I mean, it highlights the fact we're moving to a different stage,
Precisely.
a different set of case management decisions.
Yes, post the award, post the
the
overall award.
Which is why, arguably, distribution is different to award of damages.
Precisely. It's the award of damages is the prior stage.
Yes.
Then arises the question of distribution. We are at a very early stage in these proceedings. It is simply not right that the class representative can set out for the tribunal or your lordships now what form distribution is going to take. It's just too early. But there's certainly no bar to looking into approaches like direct credit.
That's the important point here, as to whether or not that would be precluded
In
as
due
one of
course.
the menu of options in due course.
Precisely, and we say it can't be right that it could be precluded. The tribunal may well want to hear from the class before it makes a decision. But these are questions for another day. That is why the tribunal did not express any firm views. It did not need to express any firm views because it wasn't the operative part of the decision on the opt-out question. So that's why I say this is essentially a sideshow.
But the only reason we're looking at it, isn't it, is because of the argument being advanced on either side, particularly by the opponent, that there is no distinction between opting in and making a claim for damages. And that's where this comes in.
That's correct. So it comes in because of BT's argument
Yes.
that if you can take the monies at the end, then you can opt in. That's
Yes.
why the point
But your
arises.
argument that it's a sideshow, in a sense, leaves their argument as a potential problem for you, doesn't it?
Well, it's so my principal position is it's a sideshow, it's a distraction, because the tribunal's finding wasn't contingent on direct credit. However, my secondary submission is nonetheless BT is wrong to say that direct credit is precluded, and it may well be the case that that's an efficient way of getting the money to the class. So they're not inconsistent, but the more important point is whatever the steps are that need to be taken at distribution, don't dictate the question of whether these people will opt in sufficient numbers to render an opt-in proceeding viable. So my third point I think we've covered, which is the tribunal didn't make any decisions or findings about distribution, it made observations. Then turning forth to BT's claim that direct credit is a different beast from a damages payment, in responding to that, I rely on rules 92 and 93, and that Ms Ford's submission incorporates, it essentially conflates the two. The award of damages, the aggregate award of damages, will be paid to the class representative or, for example, a claims administrator. There's no question about that. It cannot be paid to the class. That's not feasible in an opt-in, in an opt-out claim. The question of direct credit does not therefore arise under Rule 93 at all. Rule 93 is the award of the aggregate damages amount. That is the overcharge, however much that would be. Direct credit becomes relevant under Rule 92, where the tribunal makes directions as to distribution. And that's why it confuses heads of damage with a mechanism.
Well, I suppose 93 has something to say about distribution, because it, if you like, it lays down your bookends. It says the award must go to the representative or other person. It then says they may set a date, and it then, so that's right at the very beginning, and then you've got the end, what happens for unallocated funds. But everything in the middle, which is not expressly dealt with by 93.
It is then,
So-
that's true, that's fair.
That really takes you back to the case management powers of the tribunal, which are unfettered and unlimited.
That's
There's no lacuna, it's just that they bookended some. There's a number of matters the legislature in drafting the statutory instrument said we need to deal with something specifically. And there's an enormous terrain in the middle, which has to be dealt with by just ordinary case management.
That's the position. As I say, the headings don't help. They're not useful signposts because 93 is really aggregate damages, and then, as you say, the conclusion of the distribution process. Rule 92 is not assessment of damages. It's distribution. It's individual apportionment post the assessment of damages. So it strikes me as
I don't really understand that. It seems to me the headings do reflect what they're dealing with.
well, the assessment of damages is really Rule 93, which refers to the award of damages. That's your award of aggregate damages. Rule 92 is the assessment of individual apportionment. It's not the overall, and it only becomes effective after you have an award of aggregate damages under Rule 93.
What 92 is saying is that it's dealing with the assessment for the amount that may be claimed by each individual.
That's distribution.
Well, no, I think that's the amount of damages, how you assess what damages each is entitled to. Distribution is how you actually dish it out.
So, with respect, I differ on that, my lord, because what 92 says is where the tribunal makes an aggregate award of damages. In other words, it's assuming that that award has been made, 500 million,
The
let's
aggregate
say.
amount.
I think it would be more accurate if the heading were assessment of damages claimed by individual represented persons, because that's what it's what subparagraph 1 is then addressing, because it says where the tribunal makes an aggregate award of damages. So by definition, the tribunal has assessed the amount of overall damages that are
Precisely.
recoverable. And this is then dealing with what happens if an individual member of the class comes along and says, well, I'm entitled to not to £300, but to £3,000 for the following reasons. And this is then giving the power to the tribunal to give directions in relation to that, including, for example, the appointment of an independent third party to determine any dispute with the class representative and so forth, and then notices for hearings and so forth. And then 93 is dealing with, as it were, the next stage. If you've resolved any issues or haven't had any issues about individuals, you then look in an opt-out case, you have to do this. It has to go to the class rep or somebody else. Then it's, as my lord says, it's completely silent about how you actually distribute to the individual claimants in the class, assuming that none of them have raised a point about being entitled to a particular amount.
So
It just deals with what happens when if there's something left at the end of the day. And my lord must be right that insofar as an issue comes up for determination by the tribunal about what you do in the bit in between, there's an unfettered discretion. So if the class, and you're absolutely right, this is all looking at way down the line, and assuming the claim succeeds, when the tribunal has made its award for £589 million,
yes,
and let's assume that none of the individual members of the class have popped up saying, well, I'm entitled to 588 of that 589 million. Then at night under 93, it goes to the class rep, and the class rep says to the court, to the tribunal, well, actually, I'm going to need a bit of help here because there's 2.3 million of these people, and BT have got all the records of who they are. And rather than having to distribute £150 here and £250 there to 2.3 million people who would need to be notified, the way to do this would be, the best way to do this would be by way of an account credit for each of those customers who are still BT customers.
yes.
And at that point, the tribunal, if it considers that that's the appropriate course in the circumstances, would make an order to that effect.
Yes, I broadly agree with that account, my lord, but I think my reading of Rule 92, Rule 92.1, where it says the tribunal shall give directions for the assessment of the amount that may be claimed by individual represented persons, I think that is a reference to apportionment. And that's why it then looks at a method or formula. So I think what it's saying there is once you've got your £589 million, that has been ordered and that will be paid to Mr Le Patourel or his claims administrator, then the tribunal is going to tell us how to apportion that between the class.
Well, that's the point at which it may be that if it's the only practical way of proceeding, that the tribunal says, well, the 589 million is divided by 2.3 million.
Exactly.
And they get,
exactly.
each get 333 or whatever
Yes.
the figure is, 233.
And that
In fact,
precedes
the range
distribution.
is
And
100.
then the next stage is distribution. How do you, in practical terms,
Yes.
get to each individual the 233
Yes.
pounds?
So you're quite right. Your Lordship is precisely correct that there are two elements. There is apportionment, and then there is method of distribution. I would assume that method of distribution would be swept up in Rule 92 and dealt with at that hearing, the Rule 92.3 hearing, because they go hand in hand, really.
Yeah.
Either way, I think we have a range of better headings that might be
Just
deployed.
your last point. The apportionment directions under 92.2 are merely a power to may. So
It's
it
discretionary.
doesn't prevent the tribunal saying, well, actually, we may have to address this later on, but they do have the power to do it at that stage. It must just give directions for assessment of individual amounts under 92.1.
That's also.
But it is all pre-distribution on this. It's just how much money is it? Just 250 quid. Everybody gets it. Like we've done a bit of testing on pass on. We decided it's just not worth a candle. We're going to knock a quid off everybody or something like that. Or all
Yes.
the non-VO customers or something like that.
So that's on quantum, but stepping back, I think the principle, what the tribunal referred to as the governing principle, is that the tribunal is going to hear from the class before it does any of this. So there's no reason why they wouldn't hear from them on method as well as apportionment, particularly if one's looking at doing something a little bit different. Last point, responding to BT on paragraph 93.3. BT's submission there is that the statutory scheme contemplates active steps must be taken by class members. Now, Rule 93.3 entitles the tribunal to make an order specifying the date by which represented persons shall claim their entitlement. The tribunal is right to observe that this is a discretionary power to make an order, and to say that this insists on active steps is an entirely contrived construction of a discretionary order to make a power. And as ever, one comes back to the statutory purpose, which is to vindicate rights to compensation, not to place unnecessary barriers in its way. So I would, in my submission, the tribunal's analysis of this point, paragraph 118, is the right one. If distribution can be achieved more simply or efficiently without active steps, the existence of that discretionary power doesn't preclude the tribunal from ordering it. My lords, I come to the last ground, which is strength of the claims. And you've heard BT's argument that the tribunal applied a de facto threshold test, that the claims must be very weak. Now, if I could ask your lordships just to have the relevant passage of the judgment.
Maybe there's not so much between the parties. Do you actually say that if that is what the tribunal is saying, it's correct, that before an opt-in can be ordered, it would have to be shown that the claim was very weak? Do you say that?
No, I don't say that, my lord.
So if that is what the tribunal was saying, no one really says that's correct.
It's just an infelicitous way of expressing themselves, isn't it?
That would be my
Because that's
submission.
exactly what they go at the end of that paragraph. They say for all the reasons we've already given, this is as it were a bad point, and that's a reference back to the previous 38 paragraphs where they
Precisely.
strike out application.
Precisely. The tribunal was dealing with the facts before it, which were that BT made extensive submissions on merits for the strikeout application, and BT also argued in its response to the application for a CPO that the claims were more suited to opt-in because of what BT termed their fundamental deficiencies. So that was BT's submission, that it was fundamentally deficient, and that's why it should be forced into an opt-in action. And the tribunal didn't agree that it suffered from fundamental deficiencies, and BT's merits arguments did not find favour with the tribunal. Not one of them was accepted. To the contrary, BT's attacks were variously rejected by the tribunal, and I quote, as unfounded, hard to follow, speculative, and so on. Now, a number of BT's merits challenges concern the significance of the Ofcom review. Rejecting them, the tribunal held that the review is a relevant and persuasive piece of evidence. And if I could just briefly show you on this, paragraph 52 of the judgment, which is at page 360. Rejecting BT's argument, they said that hardly renders the review invalid. It's plainly focused on the excessive pricing of BT as a direct result of its market power. It also needs to be remembered that the PCR's case is not that there is some automatic read across of the review so as to found the claim. Rather, the PCR relies upon the review as a piece of evidence. Given that the object of Ofcom here was to consider the question of excessive pricing, it would, in our judgment, have been very odd if, for present purposes, the PCR did not consider the review as being highly relevant. It is, as the PCR submits, the most up-to-date and comprehensive body of evidence relating to the subject matter in issue in the public domain. So, even though this is not a follow-on claim, which relies on the binding effect of the Ofcom review, it doesn't, there's a strong prima facie case of abuse here for these purposes. So the tribunal was entitled to say, in those circumstances, well look, the strength of the claims would have to be very weak to persuade us that they weren't suited to the opt-out procedure, given everything we've said about the merits, which is that they're good, and there's the review, which is highly persuasive. And also, given its prior finding in the opt-out section, that opt-in proceedings wouldn't be viable. In other words, the tribunal had said in this case, an order that opt-out proceedings are not available would stifle the claim from the outset, and these customers would be denied a trial and have no redress. And that's redress for charges on BT landlines, which Ofcom had found to be above the competitive level, and which Ofcom said did warrant its direct intervention in price for VO customers. So that history of scrutiny and regulation by Ofcom, which is in place to this day, demonstrates that this is not a case in which the merits of the claim were in any serious doubt. So even if it's right that it is infelicitously worded, that is how I would suggest that the paragraph be understood in that context. And again, the approach to strength of the claims was consistent with this multifactorial assessment. Merits is only one factor of which the tribunal is entitled to take account. My Lords, I was then going to make one final remark, a broader remark that deals with the grounds, which is I have in mind that the order granting permission to appeal referred to the implications of this appeal for other cases. Now, I hope I have focused on the facts in issue here, and as I said, it's a highly fact-sensitive exercise, so I would be trepidatious about suggesting universally applicable rules. But what I would say by way of concluding remark is that granting BT's appeal and withholding the opt-out proceeding from this class would have serious repercussions for the future of the collective regime, potentially turning the clocks back to a time when the only available procedure was the opt-in action, which is generally understood to have been a failure, and which is what prompted the introduction of the opt-out regime. Now, that would frustrate the statutory objective articulated by Lord Briggs, re-erecting barriers in the way of access to justice for consumer redress for competition law violations, and discouraging funding. So, my Lords, unless I can be of any further assistance, that concludes my submissions.
Thank you, Mr. Crosby.
My Lords, I'm conscious of the time. I'd like to make 4 short points by way of reply.
Yeah.
The first one concerns what's in BT's defence. The submission was made by Ms Kreisberger without actually taking you to the defence, that we have in some way qualified in our defence the proposition that one can contact customers, identify and contact the class.
I wondered about that. It's slightly surprising.
Indeed, in our submission that is not a correct characterisation of what's in our defence. Perhaps I can show you first the paragraph to which we're pleading to. It's the claim form, tab 7, page 144.
It's not always sure you do accept you've got that data, and if necessary, in large measure, you can contact and identify.
We positively rely on that, my Lord, yes. I do think, though, I need to correct this misapprehension
It's
about...
slightly surprising because I thought it was a whole part of your case.
My Lord, indeed.
Well, do we need to look at it? I mean, we can look at it if you like, but...
Do you want to give us the reference?
I can give you, Your Lordship, the references. The paragraph we're pleading to is paragraph 105, and it's the proposition is that in the light of the commitments that BT made, it ought to be able to tell essentially the customers that belong to the proposed class and the proposed subclasses. So that's tab 7, page 144, paragraph 105. The defence, where we plead back to that, is core bundle tab 10, page 304, paragraph 37. And we simply make 4 short points. We say, well, first of all, insofar as you're pleading the effect of the commitments, we can't distinguish between those groups prior to the timing of the commitment, so it's a timing point. Second point we make is that the difference between the classes is whether or not they took broadband, and we say, well, we don't know whether a member of a class purchased broadband services from a non-BT provider. We say we can't identify the members of the class that are business customers, which is relevant to our downstream pass-on, and we say that BT is unable to identify as between those deceased members of the class, those who have a UK domiciled personal representative and so forth within the class, and those who do not. Those are the 4 points we make in our defence. We absolutely do not in any way cast doubt on our ability to identify and contact the members of the class in the sense required for the opt-in, opt-out question. Ms Kreisberger had an exchange with my Lord Justice Phillips about the proposition that it would not be desirable to have 2.3 million people opt in because that would entail 2.3 million individual pieces of paper. I make 3 short points in response to your Lordship's proposition on that. The first is, in our submission, it's not the test to ask whether or not the class representative would prefer not to have to deal with a certain number as a piece of paper. The test is whether or not it's practicable to do so. It's not a comparative test. It's not asking, essentially, is it preferable from the class representative's perspective to have opt-out rather than in. It's simply, is it practicable to operate this in an opt-in manner? And in our submission, certainly, if one is applying to be a class representative in respect of a large claim, one must anticipate having to handle large numbers of claimants and applications. In my submission, it's not the right test to simply say, well, one would rather not have to have that many pieces of paper.
I don't think anyone's suggesting it would rather not have. I think the question, seems to me, that can be posed is it practical, pragmatic to have 2.3 million claims for £100?
Well, my Lord, insofar as practical or pragmatic is intended to achieve something different than practicable, which in my submission means workable, to use the wording in the guide, it is simply not the right test. The test is, can it be done in an opt-in manner? And in my submission, there's no reason to suppose that it can't.
Sorry, can it be done
In an opt-in manner?
Well, it can be done, but it's going to be a completely painful and costly exercise. So it might be said it's not practical.
Well,
Well, it doesn't say can it be done. The answer is can it be done? Well, yes. But the question is it pragmatic?
in my submission, the test is asking, is it practicable? And that is not, is it
They're
pragmatic
entitled
in
to
my
look at
submission?
all the circumstances in making that assessment. And one of the circumstances must be, you've got 2.3 million people who you're trying to encourage to opt in. It's going to be a lot of administration and a lot of paperwork, which is going to cost a lot of money, none of which is necessary if you've got opt-out.
In my
Why isn't
submission,
that part
none
of
of that demonstrates that it's not practicable, my lord. That is the distinction that I'm
Practicability
drawing.
is one part of the test. Merits is another part. Everything under the sun is another. Everything in relation to suitability under 79(1) and 2 is also part of the test.
My lord, I don't dissent for any of that. The simple point I make is that it is important to retain the perspective that when one is looking at what is practicable,
It's different to desire.
Yes.
if it is doable, then it is
Yes.
practicable.
We've got that point.
Your Lordship quite fairly recognised that the tribunal didn't actually make that point in its judgment, and I do make the submission that it's somewhat unsatisfactory to be shoring up reasoning that wasn't present in the judgment. And the final point is to simply emphasise that if the fact that there is 2.3 million people in the class is treated in this way, it becomes almost determinative. And on a fair reading of the scheme and the legislative background, the scheme doesn't say all consumer claims will now be opt-out. It doesn't say opt-in claims are now to be reserved for businesses. It's clearly more nuanced than that, and that, in my submission, is a too simplistic approach.
Well, looking at all the factors in the round, one takes into account in that context that in 79(2), one of the factors is the size and nature of the class.
My lord,
And here we've got a huge class, and the nature of it is such that asking them to make individual claims may be difficult.
my lord, that's certainly a factor that the tribunal would have been entitled to take into account, albeit that it doesn't refer to that in its reasoning. It does, in my submission, come back to the fact that it's very clear it's not that simplistic. The answer is not this is a large class and therefore opt-in is not viable. It simply doesn't follow like that in my submission. The third point concerns paragraph 32 of Lloyd and Google, and my Lord Justice Flo made the point that that made reference to the possibility of not complying with the compensatory principle because it might be impractical, and your Lordship posed the possibility, well, might that provide support for the approach to providing an account credit? In my submission, what the Supreme Court is referring to there is the notion that you don't need to calculate the exact amount of the loss suffered by each individual in the class in order to then distribute the aggregate award of damages to them. So it's talking about the quantum of the award, and you don't have to maintain an exact compliance with the compensatory principle for that purpose. And that is consistent with what's going on in Rule 92 that the court had an exchange with Ms Kreisberger about. There again, what's contemplated is the tribunal is going to exercise a judgment about how you divide the amount of the award. It is materially different in my submission, and it is not saying either in Lloyd and Google or in Rule 92 that one can instead offer something else altogether by way of compensation, something which in my submission is less than an award of damages, is less fungible, less transferable, less useful to the class member than a straightforward award of damages. And it does raise a particular issue in the circumstances of this case, because as we've heard, the core of the class representatives' complaint is that the class members in this case do not have a predisposition to switch suppliers. And it's a somewhat surprising method of compensation for the class representative to be advocating, to have essentially a credit which must be deployed as against BT's accounts. In circumstances where the complaint is that they won't switch, because of course that has the effect of tying in the class members into their accounts. In that context, Ms Kreisberger's submissions about the possibility of having a direct credit to class members where, if I might describe them as lukewarm, she made the point, she repeatedly emphasised the point that the tribunal hadn't made a final decision on this point, and she characterised it as a sideshow. It's not a ringing endorsement of the tribunal's reasoning on this matter. In my submission, that's understandable. It is in my submission, but potentially highly problematic.
I think she was simply making the point that it's not a critical part of their reasoning. If she's right about that, then it's a sideshow. And they may be right or wrong about it. And you put up some quite compelling reasons for supposing they're wrong. But if we were to conclude that it doesn't actually matter because they've decided the case on a different basis, then anyway.
My Lord, I do take issue with the proposition that it doesn't matter.
Well, I follow that.
Very clearly a material part of the reasoning.
I follow that.
My Lords, the final point concerns judgment paragraph 120, which was a point that Ms Kreisberger made in her submission. She placed considerable emphasis on the fact that the tribunal said it would make the same finding in respect of split purchase customers. And she said that the tribunal was making a general point about willingness to embark on litigation as opposed to the willingness to sign up and collect an award at the end of it. And she made the submission that although Lloyd and Google post-dated the judgment, that was the general effect of what Lord Justice Leggett was saying in relation to inertia. And the simple point I would make in response to that is that that characteristic that has been identified and relied upon as supposedly supporting opt-out is argued to be a universal tendency. It's a tendency which, if acknowledged, would be a feature of all claims. Not just all consumer claims, but all claims. And if that's the case, then that sort of reasoning is going to lead to a situation where you would never have a claim which could be opt-in. And Ms Kreisberger equally made the submission, well, I'm emphasising that this is all a very fact-specific, context-specific, careful, nuanced assessment. And so this is not a situation where you can make the sweeping submission that this is always going to lead to an opt-in claim. But that doesn't work in my submission for this reliance on inertia in Lloyd and Google, and indeed the general reliance on a lack of desire to embark on litigation in paragraph 120 of the judgment. There's no reason, that is not a characteristic which is in any way specific to this class or this claim. And it does lead to the conclusion that that feature would be present in every claim. And so you would never see an opt-in claim on that basis. And that, in my submission, does undermine the reasoning in that respect.
Could I just ask you one more thing about 79.3, so I understand? What I understand you're suggesting is that the term practicable there would be interpreted as meaning, you said doable, feasible, whatever. What I wonder is, if that was right, what is the meaning or purpose of the phrase including the estimated amount of damages that an individual class member may recover? Because it's hard to see how the amount of recovery goes to whether it's feasible.
Well, I certainly understand the argument being put against me is that the amount of the recovery does go to whether it's feasible in some way. It certainly doesn't go to the ability to contact the class members, for example. But
it can only go, can't it, to conversion.
It goes to the willingness to participate, doesn't it? I think it's the point I made earlier in your submissions that that's what it's focusing on. Otherwise, the estimated amount of damages individual class members may recover.
And what seems to me is that
Doesn't seem to be relevant.
in terms of the synonyms for practicable, we're looking at those realistic, sensible, reasonable, useful, suitable, expedient, helpful, constructive, etc., rather than is it doable? Is it possible?
well, my lord, the word used by the guide is workable, because the guidance it gives when it gives the indication of the two factors that might well point to an opt-in being workable in the interest of justice. In my submission, it's using that as a synonym for practicable, and in my submission, the use of the word practicable is as intending to draw a distinction between that question and the question, the characteristics your lordship's just identified, that it might be in some way preferable from the class representative's point of view to run it as an opt-out. This is the tribunal is being asked to exercise a control, and it's being asked, is it practicable, is it workable to do this as an opt-in?
If you're right, it feeds back into the balancing exercise into which everything else under the sun is thrown under 79(1), 2 and 3. So let's assume you're right, it's doable. Something else goes in on the other side of the equation. It's doable, but not terribly satisfactory from an administration point of view, or it's very costly. I mean, it doesn't really add up to very much at the end of the day, even if it is doable, even if you're right, because it doesn't preclude the other more qualitative factors going back into the scales to balance it out or reduce its probative value in the scales. I mean, even if you're right, I mean, it's relevant, it's admissible, it's a factor, but it doesn't preclude anything else.
My lord, that approach would be inconsistent with what's said in the guide about the preference for opt-in proceedings, which in my submission is consistent with the use of the word practicable rather than any other. And in my submission, what is going on here is the tribunal is being encouraged to consider, is it practicable to do it in an opt-in way? And I fully accept that that then has to be weighed up with the other factors, but it would be an error in my submission to then negate the test that's been articulated under this limb by then factoring in everything else.
Well, what about specifically the factors in 79(2)(a)? It's doable, but it ain't efficient.
Yeah.
Or it's very costly under B.
My lord, I make the same submission in relation to this that I do in relation to essentially the scheme as a whole. This is not a scheme where the legislature has simply said, we've decided that opt-in proceedings no longer work, and so let's just switch to opt-out. there's a risk that if one simply says, well, whenever you've got a large class, it'd be much better if we didn't have to trouble ourselves with the business of actually persuading them to participate, let's just treat it as opt-out, then
I mean, I think it's fair to say when you look at the legislative history, even taking into account those paragraphs which really highlight the importance of opt-out, when it came to the legislation, Parliament or the legislature, the combination of the Secretary of State and Parliament, simply said, well, it's neutral so far as the legislative structure is concerned, but we'll leave it to the CAT to work out where the balances lie between big customers and small customers. And that's why it was really a matter of just open textured discretion, which may lead to trends, but they're just not pre-existing in the legislative form.
well, I certainly don't demur from the fact that there are various factors that the tribunal has a discretion to weigh up. I certainly don't contest that as a proposition. I do say that there has been quite careful wording in 79(3)(b). Practicable is quite a carefully chosen word. My lords, unless I can assist further, those are my submissions.
Thank you very much, Mr. Thank you to everybody on both sides of the court for your excellent presentations of the case. We are not going to deliver a judgment on the turn at 10 to 5 on Tuesday, so we will reserve our judgment in the usual way. We'll get it to you this term if we can, but no promises. You will get it in draft for any obvious typographical errors, not for inviting the court to reconsider its reasoning, please. If you can agree an order in due course, so that we can make an order on the day of hand down. If for some reason there are issues of principle which can't be agreed, we'll resolve them in writing. Thank you again.
All rise.